Hello, and welcome to our online What's New in Municipal Law 2020, presented by the Bureau of Municipal Finance Law of the Division of Local Services. This is part one of our two-part What's New presentation. In this part one of the presentation, we will be discussing new legislation related to municipal finance law. In part two, we will be discussing appellate tax board and court decisions relevant to municipal finance law. So, let's get started. The first piece of new legislation we'll be discussing is Chapter 53 of the Acts of 2020, an act to address challenges faced by municipalities and state authorities resulting from COVID-19. Chapter 53 was signed into law on April 3, 2020. This act was adopted to help cities and towns get through the coronavirus public health emergency by making changes to relevant municipal finance laws. Some changes in law are permanent to cover this emergency and any future similar emergency, but some changes in law were only temporary and specific to get through this emergency. Delay of annual town meeting beyond June 30th. Before Section 1 of Chapter 53 was enacted, Section 9 of Chapter 39 required that an annual town meeting take place during the months of February, March, April, May, or June. However, a Board of Selectmen or Town Council, by vote, could delay the annual town meeting as long as the town meeting completed its business on or before June 30th. Section 1 of Chapter 53 adds an exception to that June 30th deadline for an emergency that poses an immediate threat to the health or safety of persons or property that prevents the completion of the business of the delayed town meeting on or before June 30th if the governor has declared a state of emergency with respect to such emergency. This change in the law was made to accommodate towns that anticipated that they would have to delay their town meetings beyond June 30th, 2020 due to the COVID-19 outbreak and the governor's declaration of emergency. Sections 2 through 4 of Chapter 53 of the Acts of 2020 also deal with delays of town meetings due to the coronavirus. They amend Section 10A of Chapter 39 by adding public health emergency as a reason that a town moderator can recess and continue town meetings that have already been scheduled by warrant. Prior to the amendment, Section 10A applied only to weather-related and public safety emergencies. Under the amended Section 10A, during and for a period of 5 days after a weather-related public safety or public health emergency, a town moderator may, in consultation with public safety or public health officials and the Board of Selectmen, declare a recess and continuance of the town meeting to another time, date, and place certain. However, the continuance is limited to a period of 30 days. There are notice, posting, and other requirements regarding the time, date, and place of the recessed and continued meeting. These amendments also clarify that a moderator may invoke Section 10A more than once to recess and continue a town meeting during the same emergency. However, each continuance period must not exceed 30 days, and the moderator may not continue the meeting more than 30 days after the rescission of the declaration of emergency by the governor. Additionally, within 10 days after the initial declaration by the moderator of recess and continuance, a local public safety or public health official designated by the Board of Selectmen must submit a report to the Attorney General providing the justification for the town moderator's continuance. If a town does not have a moderator, the Board of Selectmen may recess and continue the town meeting under the amended Section 10A. Moderators of certain special districts may also utilize the delay provisions. Under Section 119 of Chapter 41 and Section 66 of Chapter 48, which applies to fire districts only, the moderator of a district meeting has the powers of a moderator of a town meeting. As a result, a district moderator may also recess and continue scheduled district meetings under Section 10A of Chapter 39. For purposes of Section 119, a district means a fire, water, sewer, water pollution abatement, refuse disposal light, or improvement district, or any other district formed for the purpose of carrying out any of these functions, whether established under general law or special act. Under General Laws, Chapter 44, Section 31, municipal departments are prohibited from deficit spending. The law calls such deficit spending incurring liabilities in excess of appropriation. There are exceptions to this rule, and one exception is when there is a major disaster, such as flood, drought, fire, hurricane, earthquake, storm, or other catastrophe, which poses an immediate threat to the health or safety of persons or property. There must be a declaration by the governor of a state of emergency with respect to the disaster or a declaration of emergency declared locally by the city or town. Emergency deficit spending must also be approved by the Director of Accounts of the Division of Local Services. As we know, on March 10, 2020, the governor declared a state of emergency regarding COVID-19. As a result, cities, towns, and special purpose districts could, under the existing Section 31, with the approval of the Director of Accounts, spend from available funds in the Treasury to address the emergency without an appropriation. Section 5 of Chapter 53 of the Acts of 2020 amends Section 31 to address the anticipated impact of towns being unable to timely hold town meetings and adopt annual budgets due to the COVID-19 emergency. If a town is unable to adopt its annual operating budget by July 1st, it does not have spending authority for its operations. It is not able to make payroll, purchase supplies, or pay its bills. Section 5 amended Section 31 to allow deficit spending for town operations with the approval of the Director of Accounts on a month-to-month basis in fiscal year 21 if a town is unable to adopt a budget for the fiscal year due to the COVID-19 emergency. This amendment also applies to districts, but it does not apply to cities. Cities already have authority to approve what's called a continuing appropriation budget on a month-to-month basis under General Laws, Chapter 44, Section 32, if they can't adopt a budget by June 30th. Under the amendment, the Director of Accounts must approve a town's monthly deficit spending authority. If the inability to adopt a budget continues, the Director may approve the deficit spending authority on a monthly basis as long as the emergency prevents budget adoption by the town. Once the fiscal year 21 budget is adopted, the deficit expenditure authority approved by the Director terminates and spending authority thereafter is from the budget approved by the town meeting. When the town sets its tax rate for fiscal year 21, the amount spent under the town deficit spending authority must be raised as part of the tax rate setting process if it is not appropriated when the town meeting is held. DLS Bulletin 2020-6 details the procedures for obtaining deficit spending authority from the Director. There will be information at the end of this presentation on where to find Bulletin 20-6. Under General Law, Chapter 59, Section 23, free cash is certified each year as of July 1st and may be appropriated until the June 30th following its July 1st certification date. As a result, free cash certified by the Director as of July 1st, 2019 is available for appropriation until June 30th, 2020. Many cities and towns routinely rely upon free cash to help fund their annual expenditures. This year, there was concern that cities or towns unable to adopt their fiscal year 21 budgets before June 30th due to COVID-19 would not be able to use free cash as a funding source. As a result, Section 6 of Chapter 53 of the Acts of 2020 was approved to allow the Director of Accounts to authorize the appropriation from free cash certified as of July 1st, 2019, after June 30th, 2020 for fiscal year 2021 expenditures, where the city, town, or district was prevented from adopting its fiscal year 21 budget by June 30th, 2020 due to COVID-19. DLS Bulletin 2020-4 details the procedures for the appropriation of free cash and retained earnings after June 30th, 2020. Amortization of fiscal year 20 deficits. Under General Law, Chapter 44, Section 31, deficit expenditures not otherwise provided for must be funded in full when setting the tax rate for the next fiscal year. This year, there was tremendous concern that there would be large emergency spending deficits as well as revenue deficits. So, Section 7 of Chapter 53 of the Acts of 2020 was passed to permit the amortization of these deficits over a 3-year period. Examples of revenue deficits that could result from the COVID-19 emergency are reduced meals taxes or room occupancy revenues. Although the passage of Section 7 was important at the time, CARES Act and other funding may address these deficits so that amortization is not needed. Under General Law, Chapter 44, Section 53E1/2, a city or town must vote before July 1st to establish a limit on the total amount that may be expended from each of its departmental revolving accounts. This year, there was concern that cities and towns unable to hold town meetings before June 30th due to COVID-19 would not be able to make expenditures from departmental revolving funds in fiscal year 21. Section 8 of Chapter 53 allows, for fiscal year 21 only, the continued expenditure from these departmental revolving funds at the same level of expenditure authorized by the city or town for fiscal year 20 until the city or town can adopt its fiscal year 21 annual budget. At that time, the legislative body of the city or town must adopt the fiscal year 21 expenditure limits for each departmental revolving fund. The next new piece of legislation relates to classified lands. Classified lands are also known as chapter lands because these lands are governed by chapters of the general laws. Chapter 61 for forest land, 61A for farmland, and 61B for open space and recreation land. These chapters afford special tax treatment to landowners who maintain the use of these lands as forest, farm, or open space recreation. In exchange for this special tax treatment, the municipality has a right of first refusal or option to purchase these lands when the use is going to be changed to residential, commercial, or industrial development. The process involves the owner submitting a notice to the town of its intention to change the use. The city or town then has an option to buy the land. However, the option is time limited. The municipality has a total of 120 days to either agree to buy the property or allow the proposed development to take place. Section 9 of Chapter 53 stops the clock on the running of the 120-day period municipalities have to exercise the option to purchase. The period during the state of emergency the governor declared on March 10, 2020 is a standstill time. The option to purchase will remain open until 90 days after the end of the emergency declared by the governor. If a notice of intent to sell or convert comes in during this tolling period or at any time, for that matter, DLS advises the city or town official to immediately seek advice of counsel to ensure that the rights of the city or town are protected. Next, we're going to talk about an act to further address challenges faced by municipalities, school districts, and state authorities resulting from COVID-19, Chapter 56 of the Acts of 2020, signed by the Governor on April 10, 2020. Section 8 of Chapter 56 of the Acts of 2020 permits the Department of Elementary and Secondary Education to certify a 1/12 budget for the operation of a regional school district starting on July 1, 2020, and for subsequent months as needed, in the event that a vote on the approval of the district's budget is delayed beyond June 30, 2020 as a result of the outbreak of COVID-19. The amount certified will continue until the fiscal year 2021 budget approved by the Regional School District Committee is adopted by the member towns and cities. The Department of Elementary and Secondary Education has published guidelines on the fiscal year 21 Regional School District Interim or 1/12 budget process, explaining the procedure under Section 8 and providing information about the fiscal year 21 Regional School District budget process. These guidelines can be found on the Department of Elementary and Secondary Education Finance webpage for regional districts. An act relative to municipal governance during the COVID-19 emergency, Chapter 92 of the Acts of 2020, was signed by the Governor on June 5, 2020. It addresses additional COVID-related municipal issues, including those related to town meeting quorums and the location and conduct of town meetings. During the state of the COVID-19 emergency, the Selectboard in a town has an unusual power. With the approval of the town moderator, the Selectboard may reduce the quorum requirement for any town meeting, representative or open. This power is coextensive with the state of emergency. It expires when the emergency is over. The purpose is to facilitate the conduct of business during the emergency. There are limits on the Selectboard's authority. The quorum requirement cannot be lowered to a number less than 10% of the town's existing quorum. The process is structured to allow for citizen participation in the decision to reduce the quorum. The Selectboard must publish notice of its intent to consider adjustment of the quorum. Section 7 does not define publication. It is our opinion that, at a minimum, the notice should be featured prominently on the town's website and posted where the town meeting warrant and Selectboard meeting notices are usually posted. The Selectboard must provide public access to allow the public to follow its deliberations on reducing the quorum as deliberations occur. If the Selectboard decides to reduce the town meeting quorum, the town clerk must notify the Attorney General of the adjusted and reduced quorum threshold. Section 8 of Chapter 92 gives towns with representative town meetings an option to conduct their meetings remotely. This authority only lasts for the duration of the emergency. The process is started by the town moderator's decision that it's not possible to safely assemble town meeting members in a single location and comply with state or local guidance on public assemblies during the pandemic. The moderator then requests that the Selectboard vote to hold its representative town meeting through remote participation. The moderator's request to the Selectboard must be in writing. It must specify a video or audio conferencing platform which, satisfactorily, enables the town meeting to be conducted in substantially the same manner as if the meeting occurred in person at a physical location. The moderator must ensure that the platform meets certain minimum requirements of functionality and ADA compliance. Within 10 days of the moderator's request, the Selectboard must vote on the request. If they decide to proceed with a remote town meeting, the Select Board must issue a warrant that expressly states that the town meeting will be held remotely and contains sufficient information for attendees and witnesses to access to and witness the proceedings. The Select Board does not have the final say whether the representative town meeting happens. When the members and witnesses come together through the remote platform, the meeting members must vote whether to conduct business through remote participation or not. It's an up or down vote. If the members approve the remote town meeting, business may get underway. If they do not, however, the gathering must be dissolved. Section 9 affords another alternative to facilitate town meetings during the time of COVID-19. If the Select Board determines that an appropriate venue for town meeting cannot be located within the town limits due to health and safety reasons, the Select Board can, with the approval of the town moderator, locate the town meeting in another community. Given the unusual nature of a town meeting outside the town conducting it, the Select Board must publicly post notice of the location of town meeting outside the town limits at least 10 days before the scheduled town meeting. General Laws, Chapter 40, Section 5B permits dedication of certain revenues to stabilization funds. Section 10A of Chapter 92 of the Acts of 2020 provides a local option for a city or town to suspend, for fiscal year 21, dedications of revenues to these stabilization funds or dedications of revenues to special funds created by special act. This option does not apply to revenues or receipts credited to other funds, such as departmental revolving funds, enterprise funds, cable PEG funds, or any other fund created under the general laws. The option is exercised in a town with a town meeting form of government by a 2/3 vote of its Select Board or Town Council, and in a city by a 2/3 vote of its city or town council with the approval of the mayor or manager. If a city or town chooses this option, the funds which would have been dedicated are credited to the general fund of the city or town. The option may be exercised at any time before the fiscal year 21 tax rate is set, and once exercised will be effective as of July 1st, 2020 through June 30th, 2021. Section 10B of Chapter 92 provides another local option for a city, town, or district for fiscal year 21 regarding stabilization funds. Under this option, the city, town, or district may appropriate funds from any stabilization fund created under Chapter 40, Section 5B, or a special fund created by special act for any lawful purpose notwithstanding the specified purpose of the fund. The option is exercised in a town with a town meeting form of government by a 2/3 vote of its Select Board or Town Council, and in a city by a 2/3 vote of its city or town council with the approval of the mayor or manager. This section applies only to stabilization funds created under Chapter 40, Section 5B, and special funds created by special act. As with the previous section, this option does not apply to other funds, such as departmental revolving funds, enterprise funds, cable or PEG funds, or any other fund created under the general laws. An appropriation under Section 10B from a stabilization fund established for educational purposes also requires approval of the city or town's school committee. This local option does not substantially alter the ordinary process of appropriating from or changing the purpose of a stabilization fund in cities or districts. However, it does change the process substantially in a town. Under this section, in a town, the legislative body is removed from the process. As a result, we suggest a Select Board should only use this option to fund fiscal year 21 necessary expenditures when town meeting cannot meet to fund them itself due to COVID-19. This option should not be used to fund items that the town meeting would not itself fund. Appropriations and alterations of the purpose of a stabilization fund may also still be made by a city, town, or district in the manner described under Chapter 40, Section 5B by a 2/3 vote of the legislative body of the city, town, or district subject to charter. That concludes our presentation on new legislation. The next few slides contain information on where to find reference materials if you wish further information. We thank you for joining us. If, after consulting the reference materials, you still have some questions, please feel free to contact the Bureau of Municipal Finance Law at dlslaw@dor.state.ma.us.